Good evening, you're watching Left, Right and Centre. I'm Nidhi Razdan. Tonight, in a shot in the arm for the government, the Supreme Court says the government has the right to decide policy and that auctions are not the only route for resource allocation. Is the court's opinion a vindication for the centre, as it says, which is facing heat in the coal scam? Also, as the DMK and NCP object strongly to the diesel hike and LPG cap and demand a rollback at the UPA coordination meeting today, is the Congress actually under more pressure after Mamta's exit? Those will be our debates in just a few minutes, but first, our top story tonight. The Supreme Court today said that the auction route is not a must for the allocation of natural resources, but made it clear that any policy must serve the greater public good. If it doesn't and is arbitrary, the court warned that it would be struck down. For a government beleaguered by the CAG's report on coal block allocations, which has blamed the presumptive losses on the government's delay in auctions, today's opinion by the top court has come as some relief.
It gives a sound basis for us having done what we have done.
I think that's exactly what the government had maintained earlier, and that's exactly what the court has said. So there is clarity to the system.
The Supreme Court's opinion couldn't have come at a better time for the UPA government. Under attack from the opposition over the coal allocation scam, the Supreme Court's opinion has given a much required fodder for the UPA government to attack not only the opposition but even constitutional authorities for the figures that they have attributed in terms of losses.
A 5-judge bench of the Supreme Court said the government has the right to decide policy as long as it serves the greater public good. Auction is not a must for all natural resources. Auction may be preferred, but maximizing revenue can't be the only way to serve the common good. The court's opinion effectively questions the Comptroller and Auditor General's report of gigantic losses. The CAG said these were presumptive losses because the government didn't go through the auction route for the two natural resources.
That C&AG has to work within the mandate that has been given to them. It is very easy to say the figures, 1,76 crores, 1,86, it is very easy. But the C&AG has got only the mandate to see whether the implementation of the government, the policy of the government has been done according to the rules, procedures. Today, the government's hands have been strengthened by the Supreme Court verdict, by the reference. And the BJP has now to come to the people and apologize to the nation.
Well, I have not the least doubt that 2G was a case of arbitrary allotment, that coal block allocation is a case of arbitrary allotment, and therefore this judgment has to be interpreted and finally implemented by present government and successive governments in a manner that it does not open the floodgates of corruption.
Besides, the political relief is also the enormous boost to investor confidence, as the court has given them much needed clarity coming against the backdrop of this rush of reforms. The Supreme Court's February verdict on 2G had in fact dampened investor sentiment, raising critical concerns that any policy can be questioned or struck down by the court. But today's opinion is a strong signal that the executive's power to decide policy remains. That apart is also the larger question of revenue maximization versus public good, where the Supreme Court has clearly said that maximizing revenue can't be the only objective. Every case has to be decided on merit by the government, and public good should prevail as the overriding criteria. This will also help keeping prices in check, because auctioning all natural resources could have had an impact on prices. At the same time, the government can't dispose of natural resources in an arbitrary manner. That has been made clear by the top court. While auction is the preferred route, what the government decides has to be above board on a case-by-case basis, or else, if there is arbitrariness, the court can definitely intervene.
The court warned that while it cannot and will not compare which policy is fairer than the other, if a policy or a law is patently unfair and is unconstitutional, the court will not hesitate to strike it down.
And that brings us to our first debate tonight. Does the Supreme Court's opinion vindicate the government, as the government has been claiming today? Or when you read between the lines of this opinion, is there more to it than meets the eye? Joining us on the program tonight, we have two senior lawyers, Pinaki Mishra, who's also a BJD MP. We have Dushyant Dave as well. Also joining us, Mr. D. Raja, the National Secretary of the CPI, and our two political commentators tonight, Mr. Kumar Ketkar and Mr. Bharat Bhushan. Mr. Raja, let me ask you first, what is the left's reaction to what the court has said? The government says it's a vindication of everything they've been saying. What do you think?
We are yet to examine all the details of the judgment. But at a cursory look at the certain points of the judgment, I would like to point out there is nothing for the government to celebrate. This judgment will have some serious implications because this judgment confines to 2G. It doesn't move to other natural resources, but there are general observations are made. Arbitrary allocations cannot be done, or maximizing the profit alone cannot be the criteria, but the decisions are made by legislature and executive. Now we are questioning the decisions made by executive, how the decisions of allocating coal blocks on arbitrary basis were done. We are questioning the government's decisions, the executive decisions. These decisions are not in the interest of the country. There the question of CAG report. Now on the coal block allocations, CAG has said it is financial gain to private bodies to the tune of 1.86 lakh crores. But
yes,
in case of 2G, the CAG report only says presumptive loss. But the court has upheld their position on 2G. But on 2G, the CAG report only says presumptive loss.
That the same CAG in its report on the coal block allocations has said that the reason that these companies got windfall gains is because the government did not take the auction route. Therefore, Dushyant Dave, if you could come in here, do you think, as the government claims today, do you think as the government claims today that this punctures the CAG report and the basis of the CAG report, or is the government being over-celebratory?
I think there is no doubt about the fact that the judgment restates. I think there is no doubt that the judgment actually restates what the correct legal position is. And it really proves that the legal position is that you don't have to auction natural resources. Now CAG's entire basis, very foundation was that this ought to have been auctioned, and had they been auctioned, the government would have earned part of the revenue of 1,86,000 crore. According to me, this judgment completely whitewashes the CAG report and shows that CAG really jumped the gun, which is what I have been saying for a long time, that CAG really never understood the provisions of the law, particularly the Mines and Minerals Act and the true legal position prevailing in the country. So I think to that extent the government can justifiably say that the CAG's report, and that's where really the nation will have to ponder the waste of Parliament's working days by opposition parties, that really now in retrospect shows that was totally uncalled for and was premature perhaps, or immature on the part of the opposition.
India's #1 news app just got even better. Download NDTV's new app, fully optimized for retina display, full screen view, faster response time, and Sudoku. NDTV's new iPad app. Download now.